Hello, my name is Howard Kline, and I'm a trademark attorney at Nath, Goldberg & Meyer. Today we'll be discussing the U.S. Patent and Trademark Office's recent fee increase effective January 18, 2025, and its impact on foreign trademark applicants attempting to secure registration based upon a foreign registration at the U.S. Patent and Trademark Office. Over the years, for foreign entities seeking to file trademark applications with the USPTO, one of the best avenues to secure protection has been filing what's called a 44E application. And what is that? That's a trademark application that is based entirely upon the trademark applicant's ownership of an identical trademark registration in its home country. The main benefit of filing such an application at the USPTO is one, you don't need to prove use in commerce at the USPTO to secure a trademark registration. And two, you could use a U.S. counsel to file the application in a manner that is compliant with U.S. Trademark Office policies to avoid potential office actions. The other option for these entities in the past has also been filing what's called a Madrid trademark application. The Madrid application, effectively, you base it upon your home country trademark registration, and then it gets sent around the world to the countries you designate. The upside there is you do not need to hire counsel in each separate country at the time of filing. The downside is at the time of filing these applications, you don't have an attorney that specializes in that jurisdiction, so the frequency of receiving those refusals is much higher. Effective January 18, 2025, the Trademark Office increased the filing fee for trademark applications from $350 to $550 for applications that use a free-form language in the identification of goods and services. For many of these 44E applications, the list of goods and services is quite expansive, and that's a problem now at the USPTO. And the reason it's a problem is not only has the fee gone up $200 from $350 to $550 per class, but for every 1,000 characters in each class of goods and or services, there is a $200 surcharge past the first 1,000 characters. So an application that in 2024 may have been $350 per class could easily now be $750, $950 per class. So what does that mean? As a trademark applicant, from my perspective, you have a number of options. One, work with U.S. counsel to really find out what the most critical goods and services are and file the application only for those specific goods and services. That can, one, reduce the total filing fee at the initial stages, two, reduce the costs of responding to office actions, and three, prevent expungement proceedings. Expungement proceedings are a proceeding at the USPTO that after the third year of registration, any entity can file a petition at the USPTO seeking to cancel your registration on the basis that you've never used the trademark in commerce. That's a problem for many of these applications in that a lot of these goods and services that are included are likely not being used yet. And if we structure the application at the earliest stage of the application in a manner to just include the most critical goods and services, you can avoid those fees, and you can also prevent the risk of receiving an expungement proceeding at the Trademark Office. Second, for many applications, it is likely now a benefit to file via the Madrid Protocol, especially if your client wants to include the huge list of goods and services. By filing via the Madrid Protocol, you can avoid the $200 fee per each additional 1,000 characters, and that's a potential option that you have going forward. If you have any questions about best strategies in terms of filing trademark applications based on a foreign registration and or the Madrid Protocol, we would be happy to assist. I can be reached at ip@naftlaw.com or by phone at 703-548-6284.